Alex here with part 106 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the initial version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. First thing I want to mention is I noticed several new members have signed up. I really appreciate the financial support, and I'm going to hopefully change the end screen collage to include your names once I get a few, a few moments of free time in the middle of this election. The other thing that I wanted to mention was I'm getting a lot more messages in my email inbox rather than at all the other various different places people were sending them to me before. So I definitely appreciate people sending all of those emails, all of those questions to theproperperson.com, specifically admin@theproperperson.com. It really is the easiest way for me to get back to you guys in a timely manner without forgetting to respond to you, which is something that happens quite often when I get messages in any other, area, I guess, that you could contact me. So this video goes into not much of a change of mindset. I was already really irritated when I saw the motion for Rule 11 sanctions. At the same time, I felt pretty confident because I had fended off, at this point, several attempts by my ex's attorney to get attorney fees from me. And this specific video is going to go over my ex's attorney's reply to my opposition. I can't remember anything about this reply, and so I really can't give much insight as to what we're going to be going into until we actually get to the document. And I believe the videos that covered both the motion and the opposition went into most of sort of the general principles behind what my ex's attorney was trying to do. So I'm not going to go ahead and go over all of that again. We are right now at the reply phase of the briefing process. So with all that being said, let's go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's reply to opposition to motion. Going into the first standard introductory paragraph, she identifies herself as the defendant again. She's a respondent, she's not the defendant, but as I mentioned in previous videos, these documents are usually copy-pasted, and the paralegal sometimes doesn't know to backspace out and replace certain parts of the document, so that's typically why something like this would happen. She indicates that she is the attorney representing my ex, and that she's replying to my opposition to motion. Again, guys, best practices is to indicate the specific date of the document that you are opposing or replying to. Next paragraph is that I deliberately misled the court by trying to convince the court that my demand for production of documents through a subpoena ducus tecum was not post-judgment discovery without permission of the court. So again, she's just concocting this out of thin air deliberately. So she's trying to act like that I knew the way this was supposed to be done, and that having known the way it was supposed to be done, I deliberately didn't do it that way. And again, guys, she doesn't really support this. There's no, how does she know this? Can she read my mind? Is there an email? Is there a text message? Is there something like that? I'm obviously not a licensed attorney, so I'm doing the best I can with the knowledge that I have at the time, back in 2012. So this is, to me, this is the kind of stuff that led me to create the video, Win at All Costs. Because I don't know where they come up with this stuff. They just say things, and I get it that some things are plausible, but some things they just say that have no anything behind it at all. It's just complete hot air. It's nothing. So this is one example of it. It's like, where are you getting this from? Where are you coming up with this? She could say, well, basically anything without the words deliberately misled would be a lot more accurate. Anyway, moving into the next paragraph. I love this part here. This is an attorney speaking about a non-attorney, guys. So take a step back and realize that this is a lawyer writing this, and she's complaining about me, a non-lawyer. She says that I'm sending up a smokescreen by using legalese and research. Now, she says in the next sentence, or in the next few words, that it's irrelevant to the issue at hand. I strongly disagree that it's irrelevant, but I think it's ironic to have the attorney complain. This is something typically that a non-attorney would complain about. A non-lawyer would say, hey, this isn't fair. This lawyer is using legalese to win the case. And this is a lawyer who's saying, this isn't fair. This non-lawyer is using legalese to try and win the case. So here's another thing that's funny. She says the clear language of the rule, Rule 11, what does it say? It does not change the clear language of the rule. Well, the same clear language of the rule discusses the safe harbor provision. So she's trying to tell the judge, hey, I'm trying to use legalese to get around the plain language of this specific rule. And it's like, ironically, you realize that that same rule has plain language. It requires you to comply with the safe harbor provision, and you're not complying with that either. So there's hypocrisy. And guys, this is stuff that I talk about all the time in some of my other videos. So I'm not going to talk about it too much now. But this is, I think, hopefully eye-opening to you guys what you're possibly going to go up against when you represent yourself against an attorney. And I think it helps you to know in advance so that it doesn't shock you when it occurs. And the last thing that I want to mention is to please watch that video, Win at All Costs, because one of the biggest things I point out in that video is you're going to get frustrated thinking that this opponent's attorney doesn't understand you, when in reality they do understand you, and they're just saying things because they want to try and win their case. They don't really care that it's not true. They just care as to what the perspective of the court is going to be. And part of the role of attorneys is to win the case at all costs, even if it involves confusing or duping the court into making a legal mistake. Moving on into the next session. The issue is simple. Well, the issue is simple from both perspectives. She's saying that I have to comply with Rule 16.21 in a very specific way. And I'm saying, at least now, in the future, that she has to comply with the safe harbor provision. So yeah, it's simple the way she's saying it, but you could also say it's simple the way I'm saying it. I actually have a specific video where I warn people against using certain phrases in documents, phrases like obviously, phrases like clearly. I wish I could remember the title of the video now. But one of the reasons you don't want to do those is because if something is simple, obvious, or clear, it's going to be apparent to the court. When you include it in your language, especially when you include it all over the place, you can sometimes come off as too desperate. And as oftentimes it can come off as you sort of trying to put everything into the court's head, when it's better to put a presentation before the court rather than tell the court, think these things because they're obvious, dummy. You want to say, here's my presentation. And things that are obvious will be obvious on their own without you having to tell the court that. Next is, she says that I'm she says fishing trip, but I think what she means to say is fishing expedition. That's the more common couple of words that attorneys use in these situations. And guys, a fishing expedition is where you don't really have anything to go off of, and so you're trying to just guess where evidence might be. But asking for your opponent's mental health records in a child custody case is way, way beyond a fishing expedition. So again, this is an assertion that's off the reservation. Next assertion here is 16.21. She's going to really focus on 16.21, which, as I mentioned, guys, without me relying on the safe harbor provision argument, she actually does have an opportunity to win this issue. I still feel like a fair judge would deny her motion anyway, but with the safe harbor provision in place, there should be no doubt at all that she should not get this award. It's 0% chance. And if you guys want to know a little bit more what I'm talking about, definitely go ahead and watch my video where I discuss my opposition that I filed. My interpretation of 16.21, that it does not exist to bar post-judgment discovery in its entirety, is not only incorrect, it has no basis for reality. So she's obviously getting really mad at this point in time. She says the rule is written in very basic English. Again, this communication, this type of speak, which is to try and make me look like an idiot, is, in my honest opinion, extremely disingenuous, because that same rule that is written in very basic English, she has to comply with, and she's not complying with. She has not complied with the safe harbor provision. So it's... you really have to take a look at the video self-representation bias to see how attorneys can get away with this stuff. How they can commit the same stuff that they're accusing you of doing and yet prevail over you. And that mainly goes into the things that I discussed in the video, self-representation bias. So definitely take a look at that if you haven't seen it yet. Going into the next paragraph here, she says that the only issue and arguments regarding why I wanted the records are irrelevant. I had a duty to first file a motion to reopen discovery. So we've already talked about this before. My argument should be that attorney fees should be awarded. There should be some kind of offset. Mitigation is spurious. The award of fees is a sanction for my actions in attempting to circumvent the legal language of 16.21. It has nothing to do with my ex and my relationship with her. I'm not sure what she's talking about here. She completely misunderstands the purpose of offsets and set-offs. So this is actually something that's very basic that all courts will do. I don't know why she's acting like it's a strange request. Maybe it's, again, to dupe the court into believing that it's a strange request. So when you owe money to somebody and they owe money to you, the court applies an offset to whoever owes the person money, so that the person who owes more gets that amount less the amount that the other person owed them. If you want to know more about this, take a look at the video, Offsets and Set-Offs. She's acting like this is a bizarre request, but it's actually pretty routine. Next assertion here is that my request for any mitigation of fees must be denied. This is so weird. Why is she asking for this? What she's basically asking is for the court to order me to pay my ex money, even though she owes me money. So she's basically saying this: Your Honor, my client owes Alex $1,000, but I want you to not order him to pay her the $1,000. I want you to not order her to pay him the $1,000. I just want her to continue to owe that money and have him pay her $2.7 grand. And it's like, hold on a second. If you owe him $1,000 and he owes you $2.7, obviously I'm going to have him pay you $1,700, which is $2,700 minus $100. But she's saying that the judge shouldn't do that. This is the really, really weird stuff that attorneys will do sometimes when they have that win-at-all-cost mentality and when they want to exploit the self-representation bias of the court. Ordinary people know that this doesn't make any sense at all. This is just completely bizarre. But this is what she's asking for. And she's not even explaining why. It's just completely weird to me. Like, guys, this is the type of stuff that makes me wonder how they get this. What I wonder is how they don't understand why ordinary people have such a severe distrust for the legal community, both attorneys and judges, when they do stuff like this. Because there's certain things that an attorney or a judge can do that's like, okay, that's kind of weird, but I understand that might be how it works. And then there's these other things that they do that are just completely off the reservation that make no sense at all. And when they do those things, you end up like with situations, for example, the midnight exchanges. Anybody who talks about my case and says, I can't believe your judge ordered midnight exchanges for a 2-year-old child 3 times. People can't get their head around that. It just sounds insane. There's like no other word to describe something like that. And this is the same sort of type of attitude that this attorney has, is my client owes him money, but I don't care. She doesn't have to pay him. He has to pay her. He has to pay my client, but she can owe him all the money in the world and never pay him back. Completely bizarre sort of mindset. And I think with an ordinary judge, I guess I don't want to use the word ordinary. Maybe with a different judge, you might have a situation where this doesn't go very far and the judge calls her out on it. But with this judge, she gets away with it over and over again. So to challenge the amount of the fees charged is also unfounded. The fees are reasonable, and it is this court that shall decide the reasonableness of the fees and the time allocated for the drafting, blah, 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 blah. Okay, so she probably doesn't know about the Brunzel factors, which is why and again, guys, she doesn't cite any law here. So she says, challenge of the amount of fees is unfounded. Okay, but how is it unfounded? Where's the authority? Where's the statute? Where's the rule? Where's the case law? This is just your own random opinion as an attorney. If my challenge to your fees is unfounded, you need to explain to the court why. You can't just say things and then expect the court to believe them. Or can you? As an attorney, if you know how to leverage self-representation bias and win-at-all-cost mentality, you kind of can. Moving into the next section here, we have my claim of experience in preparing my own documents and doing my own research, and I should know how to read the ordinary English language of Rule 16.21. This is really insulting conduct by her, but I mean, she's just mad, and it's starting to bleed into her writing at this point. This isn't typically how she writes, but obviously she's irritated. What probably happened here is that I called her out for the principles that I mentioned in the video, defend against attorney fees, which, as I mentioned, guys, I wish I would have included my challenge of the safe harbor provision, but I didn't. And that's probably upsetting her. It's getting under her skin. This isn't the first and this isn't the last time that this is going to occur. My history in this matter speaks volumes. Sanctions have not been leveled as of this point, but this matter clearly fits the requirements of Rule 11. It's very arguable that this is true, and it's, in my opinion, a less than 50% chance ordinarily, but again, without compliance of the safe harbor provision, she has a 0% chance of success if I had cited the rule. I didn't cite it because I didn't know. Again, guys, take a look at the video that covers my opposition. I believe it's 2 parts back in my Docket series, if I remember correctly. As a final note, the language that I use in my conclusion is telling. What? Let's see what she says here. I claim that once I have engaged in litigation, it's my responsibility to prosecute the case to its fullest. It is. That's exactly how litigation works. That's exactly what attorneys do. What is she talking about? Okay, I just don't understand the family issues are not prosecuted. Wow, my God. What is she talking about? Okay, so she's using the word prosecute as in like the literal role of a criminal prosecutor. The role prosecuting a case is used in any type of case. The person who prosecutes a case is the person who's moving the case towards its conclusion. In civil cases, it's typically the plaintiff. Sometimes the counterclaimant can end up taking over the role of the prosecution of the case when the plaintiff decides, I don't really care about this case anymore, I'm just going to let it languish. Whoever is moving the case forward is considered to be prosecuting the case. You don't have to be literally called the prosecutor, as in a criminal case, to use that language. In fact, there's cases that are dismissed for want of prosecution that are civil cases. And that's the language that the judges use, and that's the language that the Supreme Court uses. So going by her logic, you wouldn't be allowed to use the word prosecute in a civil case if you aren't a prosecutor. I don't know what she's trying to do here, but it's bizarre. Moving into the final assertion here, the defendant includes all of my arguments in my original motion as fully set forth. Okay, so she's basically reasserting everything that was in her motion. Going into the next section here, certificate of mailing. Under Rule 5, she's indicating that she sent this to my address as listed here. Here we have her request for submission. And at this point in time, the matter is briefed completely. We have her motion, we have my opposition, and we have her reply. And she is submitting this to the court for a decision. This is discussed in detail in the video request for submission. This piece of paper can seem like it doesn't matter to my viewers. Don't let yourself just glaze over this. Please watch the video request for submission if you haven't seen it yet. Next paper is certificate of mailing, again under Rule 5, indicating that she mailed this document to me. Next document here is the affidavit of Laura Turner that I'm filing. This is kind of a straggler document, guys. It would have been included with the other affidavits, but for whatever reason, it was filed several days later. I think this is because I actually got it several days later. If you want to know more about affidavits and declarations, please take a look at my video, Affidavits and Declarations. We will go through this document right now, though. So Laura Turner is indicating, number 1, she's over the age of 18. Number 2, she's been employed at Coral Academy of Science for the past 6 years. Number 3, our son is enrolled as a student in the school. Number 4, to the best of her knowledge, I am the natural father. Number 5, to the best of her knowledge, my ex is the natural mother. Number 6, I am not related to, or she is not related to either of us, nor has she been acquainted to us prior to our son's enrollment in Coral Academy of Science. Number 7, she is personally responsible for entering attendance records into the system, and that she personally recorded a total of 8 absences, and that she has printed out a record of said absences and attached that record to this affidavit. Her next assertion is that she telephonically contacted my ex to notify her that her son's absences needed to be reported to school, and her calls went unanswered. For the first 7 absences, my ex did not inform the school of the reason for the absences, and on the 8th absence, my ex informed the school that the reason for the absence was that my son did not want to go to school. This is probably the thing that really made me put all this effort into getting this affidavit put together. I wanted the judge to know that my ex had told the attendance keeper that the reason our son wasn't going to school is because he didn't want to. She swears under penalty of perjury here that the foregoing is true and correct. This bold sentence is a magical sentence. It is very specific, and it is quoted verbatim from a statute. If you want to know more about why it has to be quoted verbatim from a statute, you have to watch the video Declarations and Affidavits. I explain in that video why it has to be exactly like this for the magic of the language to work, which is to make it so that I don't have to get a notary to put their notary seal, pay for the notary, and all that stuff. Affirmation, which is indicating to the clerk of the court that this document does not contain a social security number, and my certificate of Rule 5 service indicating that I served this document personally upon my ex's attorney, which means I went down to her law office and I handed the affidavit to her staff member. Last document here is a notice of withdrawal of motion and excusal of witnesses. So here is where I decide to withdraw my motion. I'm withdrawing my motion for order to show cause, which is seeking to punish my ex, and I am declaring it moot, and I am excusing these witnesses: Carly Alameda, Jesse Storer, and Laura Turner. This is consistent with what I've talked about this so many times. I want to avoid going over it all over again. Basically, I have reached the conclusion that this judge is going to take advantage of the fact that my ex is no longer doing the things that she was doing that caused me to file the motion to modify custody and the motion to hold her in contempt. This is the motion to hold the school into contempt. And basically, The reasons for doing that is because that I believe, since my judge is going to exploit this to rule against me anyway, that I'm not going to get very far in this case, at least at this time. So I did pause to myself and think, if she does this again and she tries to sort of change her conduct, I'm going to go ahead and push through. But at this point in time, I thought, this judge is doing everything in his power to stop me. He doesn't want witnesses in his courtroom. He doesn't want to look at documentation on her mental health. He wants me to have as little evidence as possible. This is a judge who wants as little information as possible before him so that he can make a decision, which is to deny my motion. That's what he's going to basically try and do. And so all of these realizations by me at this point in time have led me to withdraw this motion. And again, guys, in hindsight, looking back, I do think that I would likely have gotten his decisions overturned on appeal, but I do think that had that decision been overturned and it went to an evidentiary hearing, he would have just ruled against me anyway. And at that point, I would have probably had no hope at winning that particular issue on appeal. If you want to know why, you have to learn about the technicalities as to how appeals work. And without knowing that, you won't understand why. Definitely take a look at my video filing an appeal, but more importantly, take a look at my video standard of review. Scrolling down, we have my Rule 5 Certificate of Service, which indicates that I personally served this document upon my ex's attorney as well. Going into the aftermath, I filed 2 documents, but I incurred $0 in costs because those were free filings. My ex's attorney also filed 2 documents. Those were also free filings, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have spent substantial time on preparing that reply, but it wasn't very lengthy. It also wasn't short, nor did it have a significant amount of legal research. There were a lot of statements that she made that really didn't point to much authority at all. I think the only thing she cited was Rule 11 and 16.21. So those things being noted, I think it's pretty reasonable to say that it took her an hour to put together that reply. And then when it comes to the request for submission, which is a pretty standard document, and then my notice of withdrawal of motion, that really doesn't require her to do any work. In fact, it takes work off her plate. So those 2 documents, I think it's reasonable to say 5 minutes. And the affidavit of Laura Turner, which she would have probably spent a little bit more time on. It wasn't a tremendously long, detailed affidavit. The only assertion that she may have been interested in was the one by the attendance keeper, alleging that my ex told her that our son wasn't going to school because he didn't want to go. So I guess perhaps she would have put about 10 minutes into that. Maybe she would have sent an email to my ex to ask her questions on it. So those 4 filings come to 1 hour and 15 minutes at a rate of $250 an hour. That comes to $187.50 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.